afternoon. This is my opportunity to respond briefly to a few of the things that Mr. Davis said. I would echo something he said earlier, which is that just because he or I do not address something in these arguments doesn't mean that it's not important. We certainly don't think that. Neither one of us do. It's simply that we don't want to be here another week repeating the same things. And I'm sure you don't either, though I also echo what he said. We appreciate the attention that you guys have given us, and will continue to give this case. So thank you for that in advance. Responding to the comments that Mr. Davis made in his argument about the civil case that some of the listed victims who testified still have, and that is still ongoing. What I would ask you, members of the jury, to consider is that in light of something else that Mr. Davis and the defense has said, which is that, in other words, they noted that these victims did not make a complaint about this to Jackson County Sheriff's Office. They have testified, you know, what happened. There's been a video presented of what happened at the time. And then Mr. Davis would point out that these people did not make a complaint at that same time to the Jackson County Sheriff's Office. Well, I would ask you to consider something at the risk of being obvious. I'll say it. Is it reasonable that they would make a complaint to the Jackson County Sheriff's Office about a deputy with the Jackson County Sheriff's Office, particularly in light of what they've already told you, which was that who was going to believe me? It was my word versus the deputy. That's how this works, I believe one of them said. So what were they left with? Well, they sued him. They went and got civil attorneys, and they sued him. What else were they supposed to do at that point? You know, they followed up in this trial, in this criminal trial, and they've come 2 years later, some closer to 3 years later. They've come here and they've said the same thing they were saying then. But the fact that they have a civil case actually demonstrates that they did do something. They did do something extra. They just didn't quit at the time. I would also ask you to consider, in light of the defense's argument, recall what these people said. We asked them, why did you plead? And not all of them did. That's an important distinction. Some of them did, for sure, and we asked them. But not all of them. The ones that did, why did you plead? Their answers varied, just like everybody in the room is different from one another, but their answers varied. They said, some of them, it was, you know, some of them were in there longer than others. Those jail detention reports that are exhibits demonstrate that. Some of them were on probation, and they did not want to risk going to prison for this. Some of them had just gotten out of trouble. Some of them had never been in trouble, and they said that they got something called pretrial intervention. Some of them felt like, what? What did some of them say? They said, no one was going to believe me. It was my word against a deputy. And you know what? Here we are, years later, and that's the argument that's being made. That same argument is being made. I would submit that that says a lot. Now, regarding the backup deputies, Mr. Davis rightfully points out that there were several backup deputies, that none of them, not one, and I don't claim otherwise, said that they saw anything suspicious and that they were there. Many times it was broad daylight, and I agree with that. I want to be respectful of other deputies who have testified in this case in the videos, because they have a hard job and they swear that same oath. I would ask you to watch those videos and decide for yourselves how attentive they really are and what they're really attentive to. I'm not saying that they're, you know, looking at TV on their phone or something during the stop. That's not what it shows. But they're not there in the stop, in the middle of the search, watching what's happening. Trooper Opry is leaning back on his patrol car talking with Joshua Emanuel. Others are standing back, making small talk with the victim as they're pulled out of the car. None of them try to get closer to the car, other than Heike. Heike is an exception during the Odom stop, but not one of them make any effort to get closer to the stop. On the Clinty stop, when the defendant walks around to the other side of the car, that deputy doesn't go around to the other side of the car. Hey, for officer safety, let me get to where I can still see everybody. That doesn't happen. So while their work is important and respected, they were not as attentive as maybe an argument has been made that they should have been, to where they would have seen these things. And I asked some of them as well, was there any particular reason you were watching? You knew to watch the defendant that closely. Well, none of them did. They weren't in internal affairs, and that investigation didn't begin until later, the testimony showed. So there was no reason that those deputies knew to follow the defendant that closely during those searches. Some of those deputies testified that they weren't surprised by denials that these drugs aren't mine, because they hear that kind of thing. Understood. But that's not all the evidence in this case. You have to couple that with the totality of all the facts in the case. And when you look at that, a denial, first of all, the type of denial, the time of the denial, immediate, you can see it on the video, you can see the reaction. You couple that as well with the fact that these things are in plain view where these people would have seen them, that they asked for testing of it. Some asked for DNA, some asked for prints, and then some asked for roadside drug tests. And then you look at all those and it demonstrates a clear pattern. So while one deputy or two may say it's not uncommon for that to happen, when you look at this whole fact pattern that's been demonstrated in this case, you see this probably isn't really what they're talking about. This probably isn't the same thing. This is something different. This is not the normal type of stop that those deputies are talking about. These are 12 stops over a year-long period where these things occurred in a clear pattern. On that note, these victims are telling you these things years later. Yes, there is a civil case going on, but their criminal case is done. And they're telling you the same thing in that witness box that they were telling you on those videos. Regarding, the why. Who, what, when, where, the why, the motive. You have to look at the surrounding circumstances to determine what's in someone's mind. We're not mind readers, but you have to look at what is demonstrated with the evidence. Well, we know that he wanted to be in narcotics. Nothing wrong with that. We know that he wanted to move up in an organization because he interviewed with CID, apparently when there was an opening, Criminal Investigation Division. There's nothing wrong with wanting more pay for doing hard work. We know that he wanted that, which there's nothing wrong with, because he worked off-duty jobs and he had applied for a position that made more money as well. We know that his father was a respected member of law enforcement, particularly in the area of narcotics. And we know that he had great authority, as demonstrated in this case. Was he proud of how proactive he was? Was he proud of all the arrests he made? Deputy Heike certainly looked up to him. Deputy Heike, the same person who asked him for pointers. Of course, the defendant wasn't able to give any. But he was certainly looked up to by another younger deputy in the agency. He was certainly known as a proactive deputy. Proactivity is something that's considered for narcotics, among other things. And maybe he just liked the power. I go back to that ID badge and what it says on there and what's demonstrated. That's tremendous power. Maybe he just did it because he could, because he had that authority, he had that power. That's for you to decide. But that's certainly a reasonable conclusion for each of you to draw based on the evidence in this case, that he did it because he could. because he liked the power and he had the authority. Now, regarding Mr. Hodges, Mike Hodges, you know, he testified that the defendant even admitted it. He recommended the defendant for the job. That he made a recommendation that this agency, the Odom video. Why a certain group? So that logic is something that I would reason is absent here, that there is no logic to it, that it is without support in the evidence of this case. Regarding the patrol car, the search of the patrol car, you know, Mr. Davis, the defendant, has testified that this was property that was left in a bathroom in a park. It was taken into his custody. He got busy because he got called to other very important calls. And as he was processing it in his car, right then is when he got called in and got suspended. And that he told Arnold, and that he told Hodges that, hey, I'm in the middle of processing evidence. It was an important day to him. Nobody disputes that. Don't you think it'd be an important day to Arnold and Hodges? Now, it's unclear what Arnold, he's independent of internal affairs, but Hodges certainly knew what was going on because he made, or at least what was under investigation, because he made the recommendation that he did. Don't you think it was an important day to them? He didn't tell them that. He didn't tell Arnold that. He didn't tell Hodges that. It's because it didn't happen. He wasn't processing evidence. It wasn't evidence. It was his stash. It was his supply. His position here is that he was processing it in the front seat of his car. You got to wonder, why is it that he's too tall and too large frame to get into Van's car to search the car the right way, or Emmanuel's car to search the car the right way, or other people's car, because that's when his camera goes out, yet he can process this evidence in this particular scenario with no other record that would exist if it had really happened. What sense does that make? Zero. Doesn't make any sense because it didn't happen. It didn't happen. There's no record that would exist if that was accurate, if that was true. And then lastly, regarding the enterprise, like Mr. Davis argued about, you know, it's a strange thing. It's a strange thing to label a law enforcement agency a criminal enterprise, and not a thing to be done lightly. And the unfortunate case here, based on this evidence that we've presented to you, demonstrates that the defendant used this agency for his criminal purposes, and that it wasn't an isolated, a one-off thing that happened and it's over, but that it was a pattern. You know it was a pattern. And you know that he couldn't have done it without the use of this agency. He used it for his own purposes, this agency, as a criminal enterprise. And I would submit to you that the evidence in this case has demonstrated that he did this and did these crimes beyond a reasonable doubt. Thank you.
Thank you. All right. It is about 2:05. We're going to take one last quick recess before I give you about 5 minutes of your final instructions, and then you'll begin your deliberations. One thing to note is when you come back in here, you need to expect that you will have probably the rest of the afternoon or until your deliberations conclude for purposes of today, where you will not be allowed to use a cell phone or any other technology for a period of time. Thus, this last recess of the day is a good time to contact family, friends, et cetera, and tell them that you're going to be out of pocket probably through the remainder of the afternoon, and give them a heads up on that. If any of you would like to be provided a phone number where, in case of an emergency, somebody from the outside can reach the court, the clerk will be glad to provide that to Mr. Gary, the bailiff, and you can provide that to any family member that may be in need of the court to get in touch with you in case of an emergency. But feel free to use this last 15 minutes to place any last-minute phone calls that you may need to do this afternoon, because, again, once we get into deliberations, you will be not allowed to use any technology for an extended period of time during that process. So understand that's where we're going to go when we come back, so use these last 15 minutes wisely. It is 2:05. We will be in recess until 2:20. At 2:20, be in the jury room. You are not in deliberations right now, so you are still not allowed to talk with each other about this case. You're not allowed to talk with anybody about the case. So if you contact family and say, hey, I'm going to be out of pocket for a little while, that doesn't give you permission to talk about the case in any respect. You cannot talk about this case at all with anybody. Don't do any research. Don't look up any information. Literally, this is your last break before we go into recess. Leave your notepads in your chairs, leave your name badges on, and be in the jury room fresh and ready to go for the rest of the afternoon at 2:20. Thank you.
All rise.
Come to rest. Just let her come in. All right, one thing I think is inappropriate to do at this point in time, understanding the court is going to go into its section of submitting the case to the jury when we get back, is if counsel will get with the clerk, look over the exhibits, just make sure that they are in order. As we've discussed earlier, this is that 15-minute period where I just want counsel to get together, make sure that how you want it presented to the jury is ready to go, ready to be sent back, and then when you're comfortable, I will take a look at it as well. So we're going to be in recess in the court for about 15 minutes and get those exhibits ready to go back to our jury.